Processing principles. The purpose of a statutory instrument is often to add duties for the entities it seeks to regulate. The GDPR is no exception in that, among other things, it forces organizations to comply with regulations, namely, comply with the principles of the GDPR, ensure constant compliance, and, finally, find the means to prove such compliance. These principles are expanded upon hereafter. First principle, lawfulness. A core principle is that a legal basis must exist for each processing purpose for such processing to be lawful. Processing of personal data is forbidden if it is not based on one of the 6 legal bases defined in the GDPR. Identifying the legal basis for the processing is thus a legal prerequisite for any personal data processing. The first legal basis is the best known one, consent. When a natural person gives his or her consent, that person allows you to process his or her data for the purpose for which he or she has given his or her consent. Consent must be easy to understand, given in clear and plain language, and easily accessible. It must be given freely, without duress, and it may be withdrawn at any time. A good example is a checkbox on a website asking for consent to send a newsletter. So, a user is prompted into positive action by checking the box himself. Such a positive action is also called opt-in. Before the GDPR, the opt-out concept was often used. In this case, the checkbox was already checked, and there was no obligation on the part of the user to perform a positive action. The second legal basis is the performance of a contract. For instance, to process a product invoice, it is necessary to process the customer's data. Compliance with a legal obligation is the third legal basis. It allows organizations to process personal data when required by law. For example, any organization with employees must comply with its legal obligations. The fourth legal basis is the need to protect the vital interests of the data subject or of another natural person. For instance, to rush to a hospital a person who faints in the street. The fifth legal basis applies to public bodies or bodies performing a task in the public interest. An example is the issuance of identity documents, which is data processing by a municipality. The sixth and final legal basis concerns the legitimate interests of the controller. Such legitimate interests must be defined by an organization when it is a controller. The legitimate interest must be proportional to the fundamental rights and freedoms of natural persons. An example of legitimate interest that may be deemed proportionate is that of a company that sets up controls to detect intrusions in computer applications. In order to detect any suspicious event, such control systems gather various types of data such as IP addresses, the place where the connection originated, etc. Second principle, fairness. Based on this principle, data may only be processed if such processing can be reasonably expected by the data subject. For instance, a data subject who subscribes electronically to a specific newsletter does not necessarily expect to see his or her data used for direct mail marketing purposes. The third principle is transparency, which requires that the data subject be properly informed of the processing of his or her personal data. This principle will be expanded upon in the context of the analysis of data conditions in the fifth topic of this training. Fourth principle, purpose limitation. It requires all data to be collected for specified, explicit, and legitimate purposes, and not further processed for other purposes except in the case of compatibility of purposes. For instance, when an organization collects data to organize a contest, it is forbidden to sell such data to third parties. Fifth principle, data minimization. This principle requires that you only process the personal data needed for the purposes to be achieved. In practice, you should only analyze the data really needed for the purpose for which it was gathered. For instance, it is inappropriate to collect medical data when purchasing a book online. Sixth principle, data accuracy. The data gathered must be accurate, and the organization should rectify incorrect data as soon as it is aware of it. For instance, when a person moves and informs his or her company, the company must update its database. Seventh principle, limited storage period. Personal data may no longer be stored past the time needed to achieve the purpose for which it was gathered. For instance, a bank is subject to the storage obligations required by laws against money laundering. It may therefore keep identifying data past the legal deadline. Past that deadline, it may no longer keep the data in a form that allows the data subjects to be identified. Eighth principle: integrity and confidentiality. Personal data must be processed in a way that ensures an appropriate level of security for such data. For instance, it is possible to set up encryption mechanisms to protect the storage or exchange of data online. The last principle is accountability. It requires organizations subject to the GDPR to be able to demonstrate their compliance to the regulation at any time.